Okay, I think we're going to get started. Good evening. Thank you all for coming. My name is Andrew Cohen. I am director of the Jean Beer Blumenfeld Center for Ethics. I also teach in the philosophy department here at Georgia State University. The United States of America has a population of over 320 million people. Roughly 250 million of those people are adults. We're going to hear a few statistics in this evening's presentation, so let me introduce a few basic ones and then offer some observations. Over 2 million persons are incarcerated in American prisons and jails. Nearly 5 million additional persons are on probation or being supervised on parole. So 7 million people in the US correctional system. That's a lot of human beings. That's about 3% of our population. And compared to other countries on the planet, particularly in the Western world, that's quite a lot of people. The United States either has a lot of crime being committed, or we're better at capturing criminals, or we've got a lot of criminal rules and they're being broken. Scholars, experts, and families in this community and other communities throughout the United States increasingly talk about what they call an epidemic of criminalization. People worry there are too many criminal rules. Some people worry that the enforcement of those rules is uneven. And others worry about the impact of all this on the poorer parts of our communities and their families. People worry about mandatory minimum policies, drug laws, and other rules. Now, imprisonment is very much a modern phenomena. As many of us know, in earlier times, crime met with swift and sometimes draconian reprisals. But citizens in modern nation states have lost their hunger for stocks and public stonings, or at least state institutions have helped us to harness our thirst for vengeance. We send our lawbreakers away to be isolated where they can do people outside no harm, but prisons are very expensive. It takes a lot of wealth in a society to support the institutions that incapacitate people away from the public eye. The expense, the stark contrast with peer nation states, and the devastating impact incarceration has on families and communities, all this has people worrying about what they call overcriminalization. We are fortunate this evening to convene a panel of distinguished experts to help us to frame this continuing controversy. Our panel today will foster further public discussion about what criminal law is, what it should do, and how it should be applied. It will consider whether talk of criminalization is on target, how so or why not, and how we should understand the role of the criminal justice system in guaranteeing things that we all care about: safety, freedom, and fairness in particular. Our experts will draw on their research as well as their work and experience on the ground with the criminal justice system, and they will help us with the controversy about criminalization. So the format is as follows. Each speaker will deliver about 9 or 10 minutes of remarks, and afterwards we'll save some time for the panelists to talk to each other, and then after that we'll open it up for public question and comment. I urge you to read more about the excellent background and careers and training of our speakers on the panel and the brochures that we have distributed. We're going to begin with presentations from representatives from the Southern Center for Human Rights, Ateeyah, Hollie, and Marissa Dodson.
Good evening. Thank you so much for having us. I am sharing my time with my colleague, and so I will move through as quickly as I can. I will start by saying that I didn't realize before coming that this might be seen as a controversial presentation, so I'm actually really excited about the kind of dialogue that comes from this. So Really quickly, in case you didn't know, the Southern Center for Human Rights is an organization that has been around for about 40 years, and what we do is we are intentional about trying to ensure justice for people who cannot afford counsel in the criminal justice system. We take everything from a low-level misdemeanor, like a traffic ticket, all the way through and deal with those kinds of issues, all the way through the death penalty. If you are curious about the work that we do, please visit our website, and I'm sure that that can be made available to you. So Andrew was referring to mass incarceration, or overcriminalization. Another name for that, as you might all have heard, is mass incarceration. And what is it, and what do we mean when we say mass incarceration? So what I have here is a chart. Can you all see here? Am I in your way? Okay, good. So what we have here is a chart that kind of demonstrates the boom that we saw in our criminal justice system from the 1980s through now. And so what you have is the jail and the prison population. What we have seen in the last 40 years is an increase of 700% of our prison population. As he mentioned, the United States accounts for 5% of the world's population, yet we have 25% of the world's incarcerated population. Mass incarceration has been seen as being driven by the war on drugs, truth in sentencing or mandatory minimum laws, and repeat offender laws, so recidivist laws that will put people in prison for very long periods of time for multiple criminal convictions. So I want to talk about the race disparities in our system, and I want to talk about them because I think it's so important that a system should be judged by the outcomes that it yields, right? So because our system has such extreme race and economic disparities, we must start from the position that our system produces these kinds of outcomes. So regardless of how you feel about why we got there, and I'm going to talk about that, we just have to be real about the data and the statistics that bear out what happens for Black people in our system or brown people in our system, and what happens when people are poor. So these graphics here kind of demonstrate the chart to your left deals with people who are stopped. So you might not be able to read it, but the furthest to the left is the white drivers. The middle is Black, and the next column is Hispanic. So who's being stopped, right? Just who's being searched. Blacks are 7 times more likely to be stopped, to be arrested, to be searched, to be charged with a more serious crime. They're seven times more likely to be sent to prison on a violation of probation or parole. When it comes to drug-related arrests, that's that second chart there. You can see that the red line is the Black population. The blue line is the white population. And then this third one really strikes me, and it's because we're talking about innocence. What is the likelihood that a Black person will be convicted, an innocent Black person will be convicted of a crime? Well, when you're talking about murder, Black people are 7 times more likely to be convicted, wrongly convicted for murder. 3.5 times more likely to be wrongly convicted for sexual assault, and 12 times more likely to be wrongly convicted of drug crimes. Economic disparities. So this idea around who is a system grabbing. What we know is that people who are incarcerated made at least 40% less than people who were not incarcerated. That the average income is less than $20,000 for people who are going into the system. What these charts represent here is, on the left, you have annual incomes for incarcerated men and non-incarcerated men, and this chart here is for incarcerated versus non-incarcerated women. So what you'll notice is those charts kind of flip, right? The likelihood of incarceration, if you have wealth or means, is much less likely than someone who unfortunately does not have means. The economic disparities play out in education as well. What we know, for example, in Georgia is that 7 out of 10 people who are currently incarcerated in our prisons don't have a GED. So the idea about who is being swept up in the criminal justice system really bears out in these kind of statistics. Here comes the controversy. So why do some of us refer to mass incarceration as slavery 2.0 or the slavery by another name? If you haven't heard of that book, Doug Blackman has a great book on that. There's a PBS special or documentary that covers kind of the end of slavery and the Civil War, and how we were intentional with our laws and policies to try to create another system out of an economic imperative. So look at the likelihood of imprisonment there on the left. 1 in 9 men have a likelihood of being imprisoned at some point in their life, but it's 1 in 3 Black men. It's 1 in 6 Latino men. And when it comes down to women, look at this women's ratio. It's 1 in 56 out of all women, 1 in 18 for black, and 1 in 111 for white women. Again, this chart here just talks about jail and prison populations with regards to our US population. I will tell you that, for example, African Americans account for about 14% of this country's population, yet we are nearly half of the prison population, 49%. So 1 million of the 2.3 million people that Andrew spoke about earlier are African Americans. How could that be, and why is that, other than either you take the position that African Americans are more criminal, we're inherently wrong, we just have something about us that just means we just can't get right, or the system is intending to have these kinds of results. And if you think about economics here, and I know my colleague is going to get into for-profit incentives and kind of what the South or what the US needed when they lost the slave industry, what we needed to do with the 13th Amendment's exception that says that it's okay to enslave people if they've been convicted of a crime, and how you watch things like the Black Codes and other types of policies start taking off as a way to figure out how we might round up labor to continue our trade. And so the convict leasing system plays out there. There are just many different things in terms of the history of our system that are the reasons why people, some people refer to this as a new slavery or slavery 2.0. These are the places, I mentioned a lot of the statistics a minute ago around where the stages of disparity are the largest, all the way through. I didn't tell you earlier that 40% of the people that are currently sitting on death row right now are African American. That in Georgia, for example, nearly 75% of people that are receive a life or a life without parole sentence are black in Georgia. And I've actually taken a little bit too much time, I'm sorry, Atia, but I tried. So I'm gonna turn it over to my colleague so that she can talk about some of the more personal work that our office does.
Do you guys hear me okay? Okay. So my amazing colleague Marissa just outlined how people of different colors and different income levels experience the same legal system in profoundly different ways. What I hope to demonstrate is the impact of these race and class-driven systems on poor people of color by putting a face to these issues. This is Wilmart Martin. He is a 63-year-old grandfather from Southeast Georgia who was sentenced to life without parole in 1991. His crime? Possessing 3 grams of cocaine, which, if you take a nickel coin, is about the weight of a nickel. When he was sentenced, Georgia had a 2 strikes and you're out law that mandated a life sentence for a second drug conviction. When that law was coupled with another law, it resulted in a life without parole sentence for certain drug offenders. When we took the case, we kind of struggled with what to do 20 plus years later. How are we going to get relief for this man who has been in prison for over 2 decades? If you have any familiarity with the court system, you know that you have to follow really stringent court dates in order to protect your rights and get any kind of court review. And being 2 decades out, Mr. Martin had pretty much run out of options. But when we started looking at his case, we realized that there were several incredible facts about his case and things that were frankly absurd. The first was that he had spent over 2 decades in prison without receiving a single disciplinary infraction in prison, which, if you work with prisoners, you know is incredibly hard to do. The second thing is that when you examined all the people who were convicted from his county, he was serving the longest sentence of anyone. That meant that people convicted of murder, armed robbery, and rape were serving sentences shorter than his. He was the sole person serving life without parole from his county. The third thing is that the mandated life without parole sentencing scheme that led to him being in prison indefinitely had been repealed several years later, but he wasn't able to benefit from it at all. But there's another aspect of his case that we found really absurd, and that was the fact that his life without parole sentence was inextricably linked to his race. The Georgia Supreme Court recognized this several years after his conviction, and you can see the stats up here from one of their decisions, but in essence, they recognized that a life-eligible black person charged with a drug offense and a life-eligible white person charged with the same offense were going to experience profoundly different outcomes. A black person was 2,700% more likely to get a life sentence than a white person charged with the same offense. Now, we represented Mr. Martin, and thankfully, 2 years later, or 2 years ago rather, a court resentenced him to time served and he was allowed to go home. Here he is. Thanks, guys. Here he is, pictured with one of my colleagues outside of his home. But we continue to do these cases, and we continue to argue for the release of men who were serving these sentences because of really minor offenses and, frankly, because of their race. One of them was Andre Mims, who was also sentenced to LWOP, or life without parole, for selling $100 worth of cocaine. He served 21 years before he was released last year. This is Darren Smith, who was also sentenced to life without parole for selling 6 crumbs of cocaine worth $110. He was released last June. That's him with his mom, after having served 18 years. And this is Mr. Tuff, Aaron Tuff, in the white T-shirt. He also was sentenced to life without parole for selling about $100 worth of cocaine. Actually, no, I take that back. He was sentenced to life without parole for possessing 0.3 grams of cocaine with intent to distribute. On this day, when he was coming out of the county jail, he had served over 21 years. We continue to represent men because we think that by doing so, we will bring equal justice to our system, and we also, with Marissa's help, work to bring fairness to our laws and policies through our work at the Capitol as well. But another aspect of our criminal justice system that really prevents us from bringing equal justice to people convicted of crimes is our system's focus on revenue generation. And I'll just tell you a quick story about one of our clients who fell victim to a for-profit driven company. Charles Jones is a 52-year-old black single father who pled guilty to driving without a license and a broken taillight. Because he couldn't pay his fine on the day of court, and for no other reason, he was placed on probation with a for-profit company. He made payments and he performed his community service and such for the first few months while on probation, but he ultimately had to have life-changing back surgery and told his probation officer that he just couldn't make the payments in a timely fashion. His probation officer's response was to obtain an arrest warrant. And several weeks later, the police came to his house at 4 o'clock in the morning and arrested Mr. Jones. The police were soon then followed by DFACs who took his children. We were thankfully able to terminate his probation, but this was the experience, and this is frankly not really a unique experience for people who are supervised by private probation companies. Now, private probation companies are not unique to Georgia. They're across the country, and they're particularly focused here in the Southeast. But here in Georgia, the private probation system is booming. We have over 35 companies who supervise 80% of the people charged or convicted of misdemeanors and traffic offenses here in the state of Georgia. And per quarter, these companies bring in $10 million. Now, these for-profit companies have a variety of ways of collecting money, but some of the ways that they employ are really disturbing. One company resorted to having a March Madness competition, and I know we just wrapped up March Madness in basketball. Well, this company held a March Madness competition where employees were encouraged to collect as much money from their probationers as possible with the promise of paid vacations at the end of the competition. Other companies held people on probation way beyond the sentence imposed by the court. We even saw one company that defined community service as having poor probationers clean the private probation company's offices. At our office, we file lawsuits, and we sue to stop these profit-driven practices. But to think that they are limited to for-profit companies would be to ignore the entirety of how our court system works and how even judges can be driven by revenue generation. We challenged a judge in Southwest Georgia who created an administrative fee out of whole cloth. He just made up a fee one day and started imposing it on the people in his court and collected hundreds of thousands of dollars before coming to his home county and asking them to increase his pay because of all the money that he had raised for the county. Thankfully, we ended that practice and got our clients their money back. There was a for-profit company that held people for ransom effectively. When defendants went to court and were sentenced, the private probation company told them that they couldn't leave that day until they made a down payment on their fine. If they couldn't make that payment, they were sent to jail. During our litigation, that company closed, and thankfully we were able to end that practice as well. There are for-profit companies who illegally drug test their probationers. Women who were in their 60s who were convicted of driving with a broken taillight are paying the company for drug tests that weren't even ordered by the court, another practice we were able to end. And then finally, a practice that we're all too familiar with, which is money bail, where people are held in jail post-arrest for no other reason than their poverty, their inability to pay a bond to get out of jail. Now, I'm really excited about the fact that we're having this conversation here today, and I really look forward to the discussion that we have. I mean, obviously, issues of criminalization of poverty and disparities within our system are of national import and national conversation right now. We at the Southern Center are working diligently every day to combat the denial of equal justice, and we invite all of you guys here to join us. So thank you.
Thank you, Atia. So please check out their website if you're interested in more of their work. There is some email and contact information for you. Our next speaker, we're delighted to have with us Benadette Rabuy. And I should also mention that tonight's event is sort of attached to an academic conference that is going on right now that's affiliated with the philosophy department, and you're all welcome to join the sessions tomorrow. We flew in a number of people to attend this conference, or at least we tried to, and Ms. Rabuy was lucky in that she arrived in between assorted acts of an angry and vengeful God. Benadette Rabuy joins us tonight from the Prison Policy Initiative, and she's going to be speaking on the topic of piecing together mass incarceration and steering clear of common misconceptions. Ms. Rabuy. Technical moment.
Hi, I'm Benadette Rabuy, and I'm the Senior Policy Analyst at the Prison Policy Initiative, and we are a national research and advocacy nonprofit based out of Massachusetts. And today I'm going to start with helping to show what the criminal justice system nationally looks like, and also kind of give a sense as to why it's a little bit misleading to think about the criminal justice system as one single system. And then afterwards, I want to give three examples of misconceptions about mass incarceration that I think we should think about as we think about reforms. So first, as Marissa talked about, mass incarceration hasn't always been the case. Historically, it boomed in the 80s, and it's remained stubbornly high. And also globally, we have a globally unprecedented rate of incarceration. So if you look at this graph, this is our incarceration rate compared to our to other countries that we consider our peers oftentimes. And this is if we pretend that the states in this country are countries. And when we map that out, we see that Georgia would then have the third highest rate of incarceration in the entire world. And blue are the countries, and pink are the states. So you can see that the second country, when we're only looking at countries, would be Turkmenistan. And that's interesting because Turkmenistan is a country that our government calls an authoritarian government. And when you look at the other countries, I'm not going to show them right now, but there are other countries with a lot of strife and genocide. So this is our system of mass incarceration. And this is really a snapshot, so it doesn't really show the growth, but it shows where people are locked up, under whose control, and for what offenses. And I apologize, it's probably a little bit hard to read, but I just want to point out a few things. For one, as you can see, federal prisons, which is that gold slice, isn't actually that large of a portion of our criminal justice system. So oftentimes, I think we learn and pay attention to some of the decisions that are made at the federal level. But actually, we can make a lot of progress with the state prison system and local jails, because those are the largest slices of our criminal justice system. And there are more people in local jails than there are in federal prison. It's also interesting, and while you can't see this here, people go to jail 11 million times per year. So not only should we think about a snapshot in time of how many people are in our criminal justice system, but we should also think about the churn. So how many people are entering these facilities? How many people are being released? Are there services upon release? Those are all things that we should be thinking about as we think about our criminal justice system. So there's a few other observations we can make when looking at this. One is that less than half of the people in jails have been convicted of anything. So as our colleagues from the Southern Center talked about, people are stuck in jail because they can't afford money bail, and so they have to wait for their trial date from the jail, and that is the majority of people who are in jails. The rest of the people in jails are convicted of very minor offenses, and traditionally will spend less than a year in jail. Second, it's not true that most people are locked up for drug offenses. However, there are a lot of people locked up for drug offenses, and most people are locked up for non-violent offenses. So those are drugs, property such as theft or burglary. So as you can see, violence, there are a lot of people locked up for violent offenses, and the way that this graph is portrayed, so let's say someone has multiple offenses, they're always going to be shown on this graph for the most serious offense. So some of those people might have a violent offense and then also a drug offense. They're going to show up there on the violent offense. Third, there are a lot of youth locked up in our criminal justice system, and thousands of youth are locked up for technical violations of their probation. So I just wanted to show this to show the growth over time and point out how much of our criminal justice system has to do with state prisons. Okay, so shifting gears a little bit to misconceptions. The first misconception is that our criminal justice system only involves prisons and jails. In reality, most people are not in a prison or jail, but they are on probation or parole, which we've talked about a little bit. So I think as we think about reform proposals, we need to be aware of this and make sure that we're thinking about things that can actually reduce the size of our criminal justice system and not just shift people back and forth between probation, parole, and incarceration. The second misconception is that privatization is only related to private prisons. So as we talked about earlier, there's privatized probation, and there's just a lot of money flowing throughout the system, whether it's private or public actors. For example, one of the issues that we work on at the Prison Policy Initiative is related to the prison phone industry. And the prison phone industry consists of a small number of companies that have monopoly-like control. Actually, the Federal Communications Commission has actually called it that it's very close to monopoly, and they charge $1 per minute for phone calls home from prisons and jails. And these phone companies also share a portion of their revenue with the counties and states that they contract with. So what does this mean? Well, it means that it incentivizes counties and states to not push for lower rates, but to actually push for higher rates, because that's money that comes back to them. So as you can see here, phone calls are at the very bottom. It might be hard to see, but it's about a $1 billion industry per year. The third misconception is that the mass incarceration only affects people behind bars. So our system really punishes families too in our communities. And so I just want to talk about something that we're working on at the Prison Policy Initiative, which is video visitation. So this is the new form of visitation that's going on throughout jails in this country. So what we have here is video technology that's being used in jails. So now when someone wants to visit their loved one in jail, they drive over, they're in the jail lobby, and they use this computer system to visit their loved one who is in that same jail, maybe in the same building, maybe in the building next door. And as you can kind of see if you look a little bit closely, there's actually not really a way to have eye contact. And as you see, the seats are bolted down, so you see someone trying to raise their child so that they can understand who they're visiting. So this is this new booming trend all throughout the country. We have about 15% of jails that are adopting video visitation. And I think it's a really important issue because it shows the ways in which our criminal justice system is punishing family members who have not done anything wrong and are just trying to be there for their incarcerated loved ones. And so I think the good news is that we've come a long way from the lock 'em up and throw away the key mentality that used to be just the only way to think about the criminal justice system. And there are examples of ways in which we are doing better. So we've seen some state prison systems decide not to take commissions, so not to accept money from those phone companies. And I think that's a step forward. I think also the attention that jails are getting is a step forward. And it's reason to have hope. So this is just an example of a young girl in California who was at a rally at the state capitol there in support of in-person visits in those jails. Thank you.
Sort of interesting competition through the wall there. We're delighted to have with us our next speaker, Ms. Sherry Boston, who is District Attorney from Georgia's Dekalb County. Ms. Boston.
All good if I remain seated here? Video? Okay, wonderful. Hold on. Is this on? Can you hear me? Great. So first, I'd like to thank Georgia State University for allowing me to be on this panel. And it is an honor and a privilege to be here with my colleagues that are doing amazing work. So you might be sitting here asking yourself, well, what's a prosecutor doing on a panel about overcriminalization and indigent legal care? And really, and there's no title to my topic in the program, and I don't know if it's because I didn't give a title or not, but if I had to title my topic today, I would say it would be the role of the prosecutor in fighting mass incarceration and overcriminalization in our criminal justice system. Because this is not a problem that can be tackled by just one side. It is a conversation that has to be amongst all partners within the criminal justice system, from prosecutors to defense lawyers to those of us, those that are working in agencies that help indigent persons, to legislators, to people of influence and accountability within our system. And so that's really important. So really, what I want to talk about is sort of what the role of a prosecutor can do and how they can play a role in this process. First and foremost, you know, I think the first thing that a prosecutor can do is recognizing that this is an issue. Because once you see it, once you see these statistics, once you understand that this is a real problem within our criminal justice system, then you can be a part of the solution. And I will sit here and say that not all prosecutors are created equal. We don't all think the same way. And there are probably prosecutors out there in the world that would disagree with the comments that I'm going to make today. So I'm saying with an asterisk that these are my opinions and views and how I intend to build the philosophy of the office I run, which is the DeKalb County District Attorney's Office. As a prosecutor who has held criminals responsible for crimes ranging from small misdemeanor traffic offenses to all the way up to murder cases, I offer, I think, a unique perspective on this issue. One might think, and we've heard that in the past there has been this lock 'em up and throw away the key mentality, and that is really what got us here, which was, you know, 3 strikes laws, mandatory minimums, recidivism statutes that really weren't connected to whether a person was likely to commit additional crime in the future, has gotten us to where we are. And so by recognizing that, I say, you know, I believe that I have a balanced approach to both prosecution and incarceration. And so part of that I definitely think comes from my perspective. I am not a career prosecutor. I started my career in law school working in the area of indigent defense. So I have represented poor people. I have represented people with means. I have also been a municipal and a magistrate court judge. And in over the last 6 years, I've been an elected prosecutor. So I feel like I have experienced every side of the criminal justice system, shy of being a defendant myself. I was going to say shy of going to jail, but anybody that's represented anybody has seen the inside of a jail cell, so I know what that's like, but I've not ever been a defendant. But I think it's important to understand that there is a role, and the national sort of movement, when we talk about the role of the prosecutor, is considering what the alternatives to incarceration are. And as an elected prosecutor, if you are not thinking about that for your community, then you are doing your community a grave disservice. Because as you can see, and I think we can all agree, that locking people up has not made crime any better. We have a lot more people in jail, and the crime rates are still the same, if not worse, than they were before our numbers spiked and skyrocketed like they did throughout the 80s. And it is very scary. Now, I say that the caveat to all this is that as a prosecutor, I still have the main function of my role, which is to seek justice for victims as well as protect the community. And I will tell you, there are some very, very, very evil people out in the world that commit very violent crimes. People that rape and murder people every day. And those are the people that we want to protect our society from. And I take that mission very seriously because every day we fight to make sure that you don't lose your life because at the hands of someone that will continue to murder given the opportunity. But as you heard, that really is a relatively small percent of our prison population. Violent offenders, as you can see from all the charts, and every chart you've seen up here is, our charts that I've seen as we've talked about criminal justice reform and numbers that are fleshed out in the cases that I see every day, which is our violent crime, albeit very difficult in our neighborhoods, still represents a smaller population than what we consider to be our nonviolent crime in our communities. So in preparing for this panel discussion, I actually came across the research of Benadette Rabuy, and I'm so glad that I got to meet her today. And, she has a study called Mass Incarceration, the Whole Pie 2017. And the study offered really what I thought was a comprehensive view of incarceration in the United States. And she's already gone over a lot of those numbers with you. I want to drill down on sort of the local jail piece of that slide, because that's a lot of what I deal with as a prosecutor in a local jurisdiction. And most importantly, one of the numbers that I want to point out that we didn't look at totally today was the fact that we have 443,000 people that are not convicted. That means these are people that are just awaiting either a criminal trial, they have been arrested and accused, but have not yet been convicted. And they face charges from violent crimes to property crimes to drug offenses. And that's an area where I believe prosecutors like myself can play a vital role in both shaping and executing policy, because that's a large number of people that are incarcerated but have not been proven guilty of any offense as of yet. It's important to ensure that these policies don't unfairly penalize the poor and disenfranchised, because the truth of the matter is, if you are a person of means and you can post a bond, unless you are charged with the most violent crimes in our community, such as murder, you are very likely to get a bond. And if you are wealthy and of means, you can make that bond, meaning there's someone out there in the world that can put up a home or have cash in a bank account to give to a bonding company, so that while you yourself remain charged and are innocent until proven guilty, you have not lost your job, your home, your children, or your freedom. And so we work very hard to make sure that we are doing the right thing at all times. And we have to have a courage to take a stand about these things. And a few years ago, before I was DA and I was the elected Solicitor General, I had the ability to do just that. And so one of the things I want to talk about, and I heard Ms. Hollie speak about the case of Mr. Jones, and the issue of private probation, which has been a traumatic problem across the state of Georgia. And I will tell you, the issue of private probation is one that was persistent in DeKalb County. And for years, the stories about DeKalb County Recorder's Court were legendary. The court had been in existence for, I don't even know, decades upon decades. And it was a court, sort of a court that had been grandfathered in by our Constitution when it was rewritten in 1983. It had been around for a long time. And for those of you that have ever driven on probably any interstate of highway, and DeKalb County, by the way, has the most interstate than any other county in Georgia. So we get a lot of travelers that are going from county to county and people that are traveling through Georgia, whether they're going to Florida or whether they're going north. And so the DeKalb County Recorder's Court was the place that prosecuted, a large number of traffic offenses for people that are routing their way through Atlanta, whether they live there or not. And at the time, we were handling about 195,000 traffic citations a year. This is just traffic type cases. This is not driving under the influence of alcohol or vehicular homicide or serious traffic offenses. These are speeding, running a red light, driving with a suspended license, driving with expired registration. But the stories were legendary that offenders were spending an inordinate amount of time in jail for infractions like speeding. And when I say inordinate amount of time, I mean people that were being sentenced to 60 or 90 days for a speeding ticket. Can you imagine getting a speeding ticket and being sentenced to jail for 60 or 90 days? But that was what was happening in this court. And in addition to that, it was a court that used a private probation company where the fees to the private probation company far outweighed the fees of the original traffic ticket. So people were being saddled with a normal traffic ticket that might cost $250, but at the end of the day, if you were poor and you tacked on fees, probation fees, extra fees, when it was all said and done, you were spending thousands upon thousands of dollars for one traffic offense. And it was clearly stated that if all of a sudden you couldn't pay those fees anymore, regardless of whether you had paid off your fines, people were being placed in jail. And this was happening right here in DeKalb County, not a small jurisdiction. It was happening right here in the metro area. And furthermore, at the time, there was also no jail calendar. So if you were arrested and you couldn't afford to post your bond, which by the way was $1,000 cash, you would sit until there was a jail calendar, which at the time was not held regularly. There was no public defender, there was no prosecutor. You just saw the judge, and whatever the judge said is what happened. So that was a system that we faced. And when I came into office and I was asked to take over prosecution in the court, I said that I would only do it under one circumstance, and that is basically if I could throw a grenade and blow up the entire building and start over. And luckily, that's what we did. We went to the legislature, and I fought hard to abolish Recorder's Court, eliminate private probation, reestablish it as a state court mandated by state rules, using a state probation system that was internal to the county, which means that they didn't make any money, they weren't making fees, and they weren't private. We also started a calendar where we no longer place people on probation for non-payment. Meaning, if the only reason that you needed to go on probation was because you couldn't pay, we put you on a deferred sentencing calendar, and we gave you a date to come back with your money. You were not placed on probation. Probation now was only reserved for people that had special conditions or things they had to do, like driving school or community service. We also converted so that you could do community service in lieu of paying fines, something that had never been offered before. So that if you had a $200 speeding ticket and you were unable to pay that because you couldn't afford it, you could convert that to community service and work off those hours in lieu of making any payments. These were all things that wouldn't have happened in my system had me as a prosecutor not insisted that these were changes that had to be made. And I was in a position of power to be able to effectuate change in order for me to convince my county that they had two options. We could either do it the right way, or they could give up all of the revenue that they would ever see from a traffic ticket, because I said they won't be prosecuted. Every ticket will be dismissed. It's your choice. And of course, that's not what the county wanted, right? So we have to be a part of the system. And so we were able to totally re-engineer a system that I felt was not only fair, due process, and observe the rights of others, but it also felt to me, because I knew it was the right thing to do. There is a way to prosecute crime, to prosecute traffic offenses, to prosecute murders, rapes, and robberies, but do it with the fairest possible way. And I think that's what we as prosecutors always have to remember. Now, traffic is easy. Nobody's life is on the line. But what gets more complicated is when we're dealing with violent crime, and more importantly, a topic that we've touched on but not had a chance, will hopefully have a chance to talk about more, which is juvenile crime, and how our juveniles who end up committing crimes place them in the adult criminal system, where they face mandatory minimums such as 10 years for armed robbery. Just this week, we had 3 defendants that were convicted. They were 16, 17, and 18 upon the commission of an armed robbery of an iPhone. It was a Craigslist ad. Please don't buy things off Craigslist and meet people in dark alleyways. That's my PSA of the moment. But that's basically what happened. The 16-year-old was a student at a high school in Dekalb County. He had no criminal record. Neither did the 17 or 18-year-olds, by the way. They'd never committed any crimes before. But somebody got the really brilliant idea to commit an armed robbery. One defendant decided to plead guilty. He's serving 7 years in jail. This 16-year-old did not enter a plea and went to trial and was convicted of armed robbery, and the judge had no choice but to give him 10 years in jail. He'll be 27 when he exits the system, because there is no early parole or early release with armed robbery under our law. The 18-year-old is yet to be tried yet. But, I mean, it is a tremendous problem when we have our youth facing these types of jail sentences. And I say jail, but I mean prison sentences, because we do have these very strict laws around certain offenses, including armed robbery. And so there really does need to be a conversation. And I do applaud our governor, who has put a lot of time, energy, and money into criminal justice reform here in Georgia, where we're starting to talk about tackling some of these issues. But for juvenile offenders, we really also need to focus on intervention, because the families involved in this case are completely and totally devastated at the loss of losing their children to the prison system. And they understand that there's nothing they can do because the crime was committed, but they're devastated at the loss of their sons. Is there implicit bias in the system? We all know that there is. Are people of color and those who are disenfranchised overrepresented in the penal system? We all know that there is. I don't think any of the comments that Marissa made were controversial, probably to people in this room. It might be controversial to people that have not yet opened their eyes to the economic and racial disparities that exist in our system, but they're absolutely there. It's documented. We know that it's true. We can't shy away from it, and I refuse to be a prosecutor that acts like that's not the case. I believe in order to usher in change, we must tackle these issues absolutely head on, and as a prosecutor and an elected official and a leader in my community, I believe it's my responsibility to create change from within, and that we are not only have to be a part of the solution, we are 100% a part of the solution. So I encourage my assistants to evaluate their cases appropriately and make the right charging decisions. And I encourage them to show mercy where mercy should be given, but also understand that this is not a win-loss game when you come to court. It's never about, I had to try that case, and so you made me work hard, and so now I'm not going to give you what I offered you 5 minutes ago. It's about justice and fairness and recognizing that one day that 16-year-old that was convicted of the armed robbery just last week will get out of jail, and he will be 26 years old. And we have to find a way to make sure that we can rehabilitate and bring him back into our society, because he is coming home to our family, and we want to make sure that he has hope and the thought that he can be bigger than whatever crime it is that he happened to have committed when he was a young person. So that's kind of the breadth of my comments. Thank you so much for allowing me to be here.
Thank you, Ms. Boston. Our next speaker is Doug Ammar, who joins us from the local Georgia Justice Project. And I think he has a PowerPoint presentation. Mr. Ammar.
Okay. All right. Well, good evening, everybody.
Good evening.
Thank you for having me here tonight. Thank you, Professor Cohen, so much. My name is Doug Ammar, and I thought what I would do, and I anticipated this would happen, so for once in my life I was right. My esteemed colleagues would set the stage that I didn't have to use some of the very slides and the very data points and some of Bernadette's great work and folks from the Sentencing Project and others. So you all have all the data. I am not going to talk about data because you have all that in front of you. I thought what I would do is just really talk about what our response is, our organization's essentially response to some of these very dire situations that we're talking about. So I thought I would describe our work a little bit, and then really that's what I thought I would do and talk about it. And many of the themes you'll see are consistent. All right, so let me just give you a quick overview about us. This is our end of the year card with the number of clients, but I liked it because it actually spans quite a few decades of our clients, but it also represents a number of things that we do in our office, both representing people in court, public defense, criminal records work. The second slide, helping folks with jobs because we stay with our folks long term, and then we work with our clients while they're in prison and their families more and more. So I'm just going to give you a quick, this is our mission statement. Yeah, I know you're dying for our mission statement. By the way, there's more material I set out over here on the left, I think. It's over there, so if you want some more propaganda. All right, so our organization, we are 30 years old, founded in 1986. We're located right down the street on Edgewood Avenue in the old 4th Ward, right behind Dr. King's grave. And one of the ways I like to talk about our work is really we focus on criminal justice, obviously, and rehabilitation. There are a number of, one of the easiest ways of talking about our work is dividing it into our service areas, people we represent and work with, and that bullet under there talks about our annual volume of cases, roughly about 75 or so criminal defense cases. We represent folks on criminal records cases all over the state. That's about 500 or so. And then because we stay with our clients long term, you'll see the 900 clients and families that we're working with long after the case is over. Or about $1 million, $1.2 million budget, and we do not take any government funds, so we're totally privately supported. So let me just talk a little bit about what we do. When I talk about direct representation in our office, we're talking about two types of things. One is being someone's criminal defense lawyer. We are not appointed by the court. We are not paid for by the government. We are totally independent. Every now and then people ask, well, then how do people find out about you? And I say that's never a problem, because we're the only alternative to the public defender in the entire state. And we are a very small alternative to the public defender. But a lot of folks don't realize that if you're poor and you get arrested, you're given the public defender in whatever jurisdiction you're in, and there is no other alternative. And the public defenders, I think the last time I checked, represent about 90+% of the folks who are arrested in the state. So, and the other 10% are often conflicted out because there's multiple defendants, like the case that Sherry talked about. At any rate, but our work isn't just representing people in that bucket of our work. We actually have social workers on staff. We assess everybody we represent before we take them, come up with a game plan for them. But more importantly, we stay with our clients long after the case is over. If our folks go to prison, the very few do, we stay with them into prison, and then we help them when they get out of prison. So that's sort of the holistic nature of it. And that part of our work is only in Fulton and Dekalb, because there's plenty of cases right here, and we don't need to drive all over the place, which is well in the wonderful Atlanta traffic. Criminal records work is something we added roughly 10 years ago or so, and in that work we represent folks all over the state, and we help people get things off the record, change the record, get a job or housing in spite of their criminal record, which is a big part of our work. And then I mentioned the social services a little bit. We also work on an advocacy level and education, and we've worked to change a number of laws in the state that relate to reentry and people with records, and that has led to us training and educating folks around the state about these issues. All right, so that's just a quick overview. I'm gonna hit, what I'm trying to get to is just some key learnings. I just wanted you to get a sense of who we are and what we do. The first thing I think we do on the criminal defense side, I see these first 3 bullets are about what our criminal defense approach is, that we try to keep folks from being convicted. We didn't talk here today about the conviction rates in this country. The Department of Justice basically says for the 75 biggest jurisdictions in the country, there's a conviction rate of roughly 80%. 80% of people who are charged with a case get convicted. And the number of those who go to prison as a result of having, or get jail or prison, just more time, is in the mid-70s percent. So that gives you some backdrop to what sort of the reality of folks who are arrested and face a charge. So obviously our approach is to try to stop that first thing from happening. And we're pretty successful at that. We generally have about a conviction rate in our office for many years of about 5%, 4 to 7% generally, but 5% roughly of our folks who have, I'm sorry. The conviction rate's about 20%, forgive me, that's 20% of our folks get a conviction compared to 80% of the national. About 5% get more jail time or prison time as a result of having a case. That's the second bullet, trying to keep folks from going to prison, which is a big part of what we do, and I think we're pretty successful there because of our approach. And then the third is to help folks once they get out of jail or prison, which is, again, a huge undertaking, but and it's unfortunately rarely done. Then I would say the fourth and fifth buckets here are really about people who have been arrested or convicted and who face barriers because of that. And we spend a good bit of our time, more and more of our time in our office working on these issues, both from an individual standpoint, but as well as a structural standpoint. I just thought I'd give you a couple data points here. I know this data point did not come up, so I thought I'd use this one. That in America, roughly 100 to about 25% roughly of Americans have a criminal record. The numbers, a recent study I read that says that essentially about 30% of working-aged adults in America have a criminal record. I'm going to say that again, 30% of working-age adults in America have a criminal record. And if you look at Georgia, Georgia has about even a higher percent, about 40% of Georgians, and this number we get, as you see, from the Georgia Crime Information Center, the state who keeps all this data, is roughly about 40% of our population have been arrested and or convicted. And when it comes to jobs and housing, and particularly jobs, an arrest can be just as devastating as a conviction. So I want to give you that. We do a lot of work on this issue, and we help get things off people's records, expungements, corrections, first offender work, housing. And I really want to chime in with what Sherry said, because the role of a prosecutor is indeed important. And in fact, actually, her office and our office are working together on an expungement, what are they calling it? Expungement day, symposium?
Expungement day, yeah.
Expungement day, which is the second expungement day in DeKalb County, which is, I don't know if there's been a date set yet. I should know this. I don't know the date. Is it?
It's either June or July. We pushed it because we needed more time.
That's right. But this will be the second expungement day DeKalb County has done in less than a year. Fulton County did one in October, and they're doing their second one in April, the end of this month. We're working with that as well. But the point is, we can't do that on our own. As defense lawyers, as a nonprofit, it takes the state, it takes folks like Sherry, it takes folks like judges and the clerk's office to come together to make that happen. And I will say this is the first time this has happened in Georgia's history, and we're seeing 4 of those within a span of a year, which is quite impressive. So thank you, Sherry, for that. I'm just giving you some data so you have a sense of what we do. Our social services, we work with our clients from the very beginning. Case management, also set up a sort of a long-term approach. We visit our folks in prison. Again, we only have a handful of folks in prison, but we still stay with them. And we also take our clients' families to visit them in prison. One of the ways we try to create community among the people we've served is every year we have 2 big client events. One's a back-to-school event, the other's a Christmas party. Those bring in about 300 to 500 folks. We actually write and communicate with everybody we've ever served, but the number tends to always be a little less than 500 folks show up for those events. And again, that's just a way of maintaining some connection with our people, and they know that we're still there, and we're still interested, and we still care about them. And then we also started a community advisory group of former clients who've been very active with us in a number of ways, and not the least of which is in our policy work down at the State House. I just threw in a couple visuals for you to get a sense of that. I like that picture a lot. One of our clients' kids. And this is a Christmas event. Okay, so that's the work. So I thought I would kind of sum up with some learnings, and many of things have already been talked about. I knew I wouldn't have to bring the raw data because it's already been delivered. But I've spent in our office, I spent a lot of time in court and in jails and prisons. And the real reason I think we exist is that too many times the people who are arrested, who face an initial arrest and are charged and face a judge, are poor and a folk of color. And what happens to them in that court system is very different than what happens for folks of means. It's already been said very well today. And I think our founder's vision when he started this organization 30 years ago was to bring the kind of representation he was used to giving as a corporate litigator, as a big firm lawyer, to the people who are poor and who don't get that kind of approach. So what do we see? We see that too many times people arrested are poor and are of color. That the system is overburdened and understaffed in every way, and I mean that in every way. I'm not just meaning public defenders. We spend a lot of our time in our office, and Sherry, forgive me for this, but trying to get a prosecutor's attention, trying to get a judge's attention, because they are overworked too. So if we're going to do a good job as the lawyer, again, we keep our caseload small so we can focus. That's part of what we do. And again, just to illustrate the difference between those with resources, people who have resources, if somebody in their family gets arrested, we already heard about how they get out of jail faster, quicker, easier. But more importantly, they hire a lawyer who will focus on their case, who doesn't have 100 or 300 cases. And that often, if there's a social service issue involved, like addiction, which so often is present with many cases, but not every case, if there's some underlying issue, good lawyers and good families will make sure those issues are addressed. And more we've seen over the years that judges and prosecutors respond to those issues being addressed. That's why problem-solving courts, accountability courts, drug courts, as you've heard of, are based on that premise, is that if we can deal with why this person got arrested, then that person was less likely to come back. That idea is more and more permeating the system from every angle, from the defense side, from the prosecutor side, from the judge's side. And so again, that's what we've been doing for a long time, and we've seen that that's one reason we have such good results, I believe. But it's good to see the system responding to. Yeah, as I said, the system treats folks differently when you've addressed those things. And again, our hope is to have different outcomes on the front end of the case, keep folks from being convicted, but even if our folks are convicted, to help folks in the long term, and even if we represent somebody who's had a record who we didn't represent, so they can have a successful reentry once their case is over and once they're out of the system. This looks like a repeat. Did I repeat it? I did repeat it. Oh my goodness. Okay, my bad. I'm sorry. All right, that's what I got. I'm looking forward to questions. Thanks.
We have a bunch of moments for conversation and discussion, and before we slide into that, let me set something up here, if you'll indulge for 10 seconds. We can hum a little tune while this is happening. Okay. always come prepared. Okay, we're going to slide into comments and questions, and as we do, some sponsors for this program have asked if you'd like to provide some feedback. There's a web link there, and you can open that up, and they ask some questions, and you can tell us what you think about the program. So what I'm going to do is I'm going to run around with a microphone, and anybody who wishes to can offer some comments or questions, and people on the panel can respond as they wish. Comments or questions? Jennifer Baker, College of Charleston.
Thank you so much. That was a wonderful opportunity to learn a ton from you guys. I was wondering if I could take this opportunity to ask about some solutions I've heard people suggest. One is that those charged ask for a jury trial. You know, I've heard that would really change the system because it'd be overwhelmed. But then you gave an example of a jury trial where the sentencing was required, I guess, after the decision. So I was curious about that. I also learned from William Stuntz's book, The Collapse of the American Criminal Justice System, that if we had localities pay for jailing people, there'd be an incentive to keep jail numbers down. And then if I can just throw out another question, are there attitudes the public has that hurts?
That was a lot of questions.
That was a lot of questions. To whom are you directing?
I'll take the first one, I guess. The issue around, you know, the theory that we could, do I need it? Can you guys hear me? Oh, thank you, Ms. Austin, you're right. Thank you. Can you hear me? There you go. So what you're talking about, so Doug said, I think 80% is the conviction rate. Was that right? So it's like 90-something% of people take a plea, right? And so that's what we're getting at, is that if people would stop taking pleas, then and went to trial, then it would kind of force the system to parse through the real cases and try the more serious cases and the like. The challenge, there's many challenges to that though. One of the primary issues is the burden that is on the individual. And the fear, what she mentioned, so when she says one of them got 7 years, right? The way that they got 7 years is that they changed the charge, because armed robbery, you can't get 7 years for armed robbery. So they negotiated and said, we will give you a plea to robbery, is that right? Correct. Robbery, and it's with the 7 years. So you're in this position as a defendant of knowing that if I go to trial, I'm gonna get at least 10 years. And what's worse is that you're subject to the maximum penalty. And there's this culture that exists that says, and she mentioned it, if you make me go to trial, and I've actually explained that to clients before, if you go to trial on this, and after the judge hears the facts and everything, if they think that you've wasted judicial time and resources, there is a possibility that you could be looking at. So a lot of that plays out. The other thing is time served, right? So the issue around who is in jail on a low-level misdemeanor, and this idea that I might not have done this, I might not think that they can prove that I did this, but when the prosecutor says, if you sign this form today and plead guilty, I'll let you, time served, you can go home. So you're saying I can go to jail, I can go back and languish in jail, right, for many months or more, or I can go home today. So I just think that some of that just puts too much of a burden on the individual to take that course.
That's right.
Yes, yes, and yes. I mean, that's all absolutely true, and I think that is somewhat of a flaw in our criminal justice system, especially on misdemeanors. Felonies is a little bit different because, if you've committed a violent felony, time served is the least of your issues, right? But in our misdemeanor system, where most misdemeanors, although are punishable up to 12 months in jail on any misdemeanor, and keep in mind that in Georgia, traffic offenses are classified as misdemeanors, so you can go to jail up to 12 months. The flaw in our system really is, and when I was the solicitor, every single one of my judges had a jail calendar 1 day per week. And so if you were arrested and you couldn't make bond on a misdemeanor offense and you sat in jail, if you came to court within 7 to 10 days, which is what it was about in our system, oftentimes you've already spent more time in jail for that offense than would be offered were you outside of the jail and you came in for your court appearance because you've bonded out. So the reality of it is, if you still can't make that bond and the judge won't give you a signature bond or release you on your own, then there is an incentivizement to say, well, fine, I'll plead guilty, I'll take a conviction just so that I can get out of jail today, go back home, pay my rent, not lose my job, support my family. And that's the choice, unfortunately, that people are given every day, and they choose to get out of jail versus choosing to fight what may be a wrongful arrest charge or making the state meet its burden, which is proving your guilt beyond a reasonable doubt. So that's the tough. That really is the tough part of our system, and that has to do with the economic disparity. Because if you're rich and you post that $2,500 bond, you'll come to court and you'll go to trial and you'll fight your case, or you will make the state prove your guilt beyond a reasonable doubt, which is what everyone has a right to do. So it's really, really kind of a tough, and I will tell you on the national level, there's a lot of discussion about whether certain, and this is misdemeanors, not felonies, which I always reiterate when people have this conversation, but misdemeanors, nonviolent offenders, there is a conversation nationally about whether we should eliminate the system of bail altogether on these types of offenses, and that's really generating the conversation. This is not about felony cases where people have committed violent crimes, and there is a concern that people will either reoffend or abscond because they're facing a lot of time. I did want to say one thing about the locality thing that you mentioned, which is the burden of, I think what you're saying, if locally there was that burden, would people be willing to make change, I think was your question. Locally right now, local jails are the burden of the locality. So, and that's why when you saw the presentation about, for example, video conferencing for visitation, which happens in our jail in my jurisdiction, sheriffs who are elected constitutional officers and for the most part are in charge of running a jail in an individual jurisdiction and who are tasked with being able to make the decisions about how the jail is run and what vendors they use for services, they are incentivized because they have to run the jail and pay for these services. So they're already, locally, counties already are responsible for maintaining their local jails. And so they are counties that need, and the Dekalb County Jail, I think, has a budget of like $113 million, maybe more, to run our jail. Everything from providing the inmates with all the services that we must provide to the salaries of all the people that go into running a jail, and by the way, the largest mental health hospital in Georgia, 24 hours a day, 7 days a week. It's an expensive operation, and it's run off the backs of these services that they can generate some revenue to continue to upkeep the jail. So I applaud you for thinking of a solution. It's just unfortunately probably not going to help maximize change.
So a couple of things I want to say. One is that DeKalb County has the largest jail east of the Mississippi. So when you think about jails, we're not talking the average jail. The largest jail east of the Mississippi. Huge. Secondly, I know what you're talking about the Stentz book, and there's another professor out of UPenn Law School who's written a good bit about this. Let me posit one idea that obviates a little bit of what you're talking about, Sherry, and that is drug convictions. So I don't know if you've heard about the drug, what do they call it, the conviction integrity units. Texas, Houston, and Dallas in the DA's office have started drug integrity units, conviction integrity units. And the idea is that where a lot of this happens is on small drug cases. And we just had a client, as a good example, as a transgender woman, and she's walking down the street. She has a workout ball, one of those tension balls, and it's full of whatever it's full of. Cops have targeted her, pull her over, do a field test, pull it out of the back of the car, field test on what's inside the ball, says, this is cocaine, you're going to jail. She's in jail for a couple weeks before somehow she gets to us. We get her out, which changes the dynamics entirely, because they say, look, take a plea, we're done. She's like, it wasn't cocaine. This was a ball. Like, field test said cocaine. And if you all seen 60 Minutes did a great piece on this. I don't know if you've heard about this, but a number of convictions around the country are based on those kind of scenarios where a really unreliable field test is a basis for a quick plea within the first month or two of a case. They offered a plea. She said no. We represented her. We waited on the drug test. It came back negative. The case was dismissed. So a number of jurisdictions, I've talked to Paul Howard about this, are thinking about prosecutors. And I really applaud places like Texas, of all places, that have conviction integrity units to say, wait a second, we're going to go back 5, 10 years later and test the drugs to make sure that those, so that's where a lot of those, the bulk of those kind of cases where folks are taking pleas are these drug cases, get out, we're done, and all that. So, sorry.
Wait, she had one question that was really, really important, which is like these thoughts and beliefs that are difficult or make our work difficult. Yes. Sorry to be talking so much, but that was a very important question. Denying that the system yields the outputs that it does is harmful. If you suggest that our criminal justice system does not have the disparities that we have, if you take that notion that poor people of color just are more criminal, then you are completely turning what we're saying on its head, right? There is so much data out there now around whites' drug use, for example, that whites use drugs far more and sell drugs more. But unfortunately, so I just think some of that stuff around like what the data bears out and coming to a realization that that's what we're dealing with, the first step to recovery is admission, right? And then the other thing that I think is this cost savings thing. Like we're saving so much money by changing around our system so that we can stop locking people up. The communities that people are coming from need those dollars, right? So I had a mentor, some of you may have heard me say this earlier, that the criminal justice system is the last net. Then when every other system fails, when the education system fails, when the healthcare system fails, when the transportation system fails, right? When all of those things, all these kids, right, just falling off through these other systems and landing in this net of the criminal justice system. So what we say is, how can we save money and stop spending money on our criminal justice system? I know how. You can invest that money in the systems that people are falling through. So we shouldn't look at this as a way to keep to have our revenues up so that taxpayers can kind of say, I'm glad we don't have to spend that money anymore. We need to be reinvesting this money in these communities and making a difference in a more meaningful way. Thanks.
My friend and doppelganger, Andrew Cohen.
So I want to ask about charges in two ways. One, Sherry, in your office, before you entered the office, though, it seemed to be common practice for the ADAs to choose charges based on what judges they thought they were going to be seen in front of. That strikes me as problematic. It also seemed like the ADAs specialized so that they knew really quickly how to get specific charges done. That strikes me as problematic. So that's all one part. Then the second part is just the stacking of charges, right? So I'm not sure why we allow stacking of charges. So, I mean, one question is, why not do the following? Why not, at the grand jury stage, require that you only have one charge at a time and it can't be changed? The DA has to specify the charge before it goes to the grand jury. That's the charge, only one at a time. And then if the grand jury indicts, then it goes on. If it doesn't, then it doesn't. It seems to me that grand juries are less likely to indict when the charges are separated out like that.
Oh, such a complicated question. Well, so to address your first question, I do not believe that our sentencing practices or our charging practices should be dictated by a particular judge. So I have instituted policies where there should be uniformity in sentencing requests, recommendations, and charges based on what we believe is proper and fair. Understanding that, I understand that there may be a judge that is going to do or want more or even less than what we've outlined, but it should not change from courtroom to courtroom. Our recommendation should always be the same based on the history of that particular defendant and the circumstances of that defendant, and the judge is not a factor. If the judge wants to do more, the judge wants to do more. If the judge wants to do less, they want to do less. But that shouldn't change the position of the state, and we should not be fueled by whomever happens to be sitting on a robe at the bench. That's just not fair, and that's just not what I believe the proper practices are. So that's easy to address. The notion of stacking charges, which I mean, I'm assuming, if I'm understanding your question correctly, has to do with charging a particular offense in multiple ways instead of just choosing one and sticking with one? Is that your question? You know, it's a very difficult notion because obviously there are certain charges that we can charge and we can prove that in a variety of ways. And oftentimes at the charging stage at grand jury, you're not totally, completely sure how you're going to be able to flesh out that case with your witnesses once it gets to the criminal stage. And so, you know, it really is something that we have to do, because if we don't indict it the right, you know, once it's indicted, that's the only way we can prove it. And that's our burden. And so, unfortunately, sometimes in cases, you don't know if you're going to lose these two witnesses and then have to prove it in another way. So, I mean, as prosecutors, it's our onus and our responsibility to make sure that we don't limit ourselves to the extent that if a piece of evidence doesn't come in or falls through, if there is an alternate way to prove a charge, that we have that ability. And I know that causes some people much consternation, but at the end of the day, the way that I see it is, if the evidence allows us to prove that case beyond a reasonable doubt to a jury of their peers, then I'm comfortable with it.
Don't be fooled. The prosecutors run the grand jury. Let's not be fooled. I mean, right? I mean, not just to be clear.
We do. I mean, I recognize that too. It's not lost on me, you know, that there is no voice of the defendant in the grand jury process, with the exception of now officer-involved shooting cases, or I guess it doesn't have to be a shooting, just officer-involved excessive force cases. Officers do have a right to speak and present evidence to the grand jury, and it's just limited to those few exceptions. Outside of that, you don't. So I do understand that the grand jury process really is prosecution-based and prosecution-oriented. But I will tell you that at least my grand juries in Dekalb, they question stuff. They would not indict a ham sandwich. I know that's like a law school joke, that, you know, the grand jury could indict a ham sandwich, and I guess under the law in theory they could. But I will tell you, my grand jurors in Dekalb, my experience with them, because they spend 2 months together hearing cases. Our terms last 2 months. So if you ever get grand jury service, I know it sounds horrible, but I think it's the best experience, and they love it, because they really get to see what happens really in the criminal justice system, and not just one horrific case. Like, you get to see a lot of things, and so it's a good experience. But they hold us to the task. They call me to make presentations. They ask questions. The most recent grand jury asked me, they wanted to get some information about officers running tags and how that works, and racial bias concerning that. And they wanted to see all the policies of all the different law enforcement agencies in Dekalb around this issue. And I had to go tell them that, yeah, you're the grand jury, but I got to tell you, you only have the right to talk to people in Dekalb County. I can't make Brookhaven come in here and talk to you. So you can subpoena DeKalb County Police Department or even the sheriff, but unfortunately all those little cities that have their police departments, you, the grand jury, don't have any control over them. But they do ask questions.
We're running short on time. We have time for maybe another question or two. Eddie Namias from philosophy.
Thank you. First of all, thank you all for your work. Along with teachers, you guys are doing the hardest job to keep our societies running well and working together. And I mean K through 12 teachers, not college professors. But we do have an adversarial criminal justice system. And so I want to put you two at odds a little bit just by asking a question about this figure that you brought up, Doug, the 80% conviction rate, and you guys get it down to 20%. And so the question is the suggestion that the difference is people who aren't guilty? Or are you trying to, so is the idea that, yeah.
No, I mean, I just gave you that to wet your whistle a little bit. And by the way, the national conviction rates overall are much higher. Marissa's right. This was the 75 biggest jurisdictions of felonies, by the way. So it's a very, I look at these DOJ reports. They've been doing it since 2001. No, I always tell people, no, 80% of our clients are not innocent. No, we're not getting that result because we select innocent clients. We're getting that result. I was trying to make the point. We're getting that result because we're approaching our clients differently. And what I'm trying to say, I've said for years, I think the system. I'm trying to be nice about this. I think the system is so ready for other alternatives that we've had so many prosecutors and judges call it the GJP pretrial. Like we come in, I'll never forget a good example of the Dekalb County case. I'm sorry, maybe it's because here. And a guy, homeless guy, in and out of jail and prison, an addict, and he was struggling. I've known him forever. I still see him. He struggles to be clean. He'll go a couple of years, be clean. So anyway, he got a case. We represented him. We said, look, we're going to help you. You got to get into treatment, or we'll get, we got him up, set up one of our counselors, going to he did a 60-60, which is 60 meetings in 60 days. Sometimes he comes around for the court, Judge Seeliger, I think, who's still there. And we put down and said, look, let me show you what our guy's doing. And the judge said, well, if he's already done that before we even get to the arraignment, right? So we're moving a client in the direction that we know the system is more and more open to. I think my point is we're providing a relief valve. Right, and the reason we were able to avoid the conviction because our clients are doing, what's right. And sometimes we're just out investigating a case, like the woman with the ball. She would have fit into one of these scenarios, which she would have taken a. Right, but that's because we have time to go look into a case. We have time to file a bond motion. We have time to, do some investigation, and all that means that we get better results. And that happens for middle and upper class folks all the time. It just doesn't happen for poor people. So again, I think. Anyway, let me stop there. So yeah, that's what I would say. But I'm trying to make this as nice as I can, and I do mean this. I have seen the system change considerably in my almost 30 years of doing this work, 27 years, whereas we used to have to go beat up prosecutors and judges and convince them, like, treat that, don't look at this the way, don't just one-dimensional it. And more, and I push on my criminal defense friends more, I say, it's the judges who have beat us to the punch with coming up with alternatives. Prosecutors, Sherry's started many diversion programs as a solicitor, and I know now that you have a new one rolling out in the felony court. My point is that people in the system are trying to find ways of not doing business as usual. And if you can set that up, you can have great results. If you can work inside that mentality that we've been working in for years, I think the system is finally open to it, more and more. Now, that's what I would say.
So I would echo what Doug said. It is adversarial in nature, but you can see we don't have to be adversarial all the time. But diversion and accountability courts have changed the face of criminal justice system, I think. Now we are in a system where, by the way, Superior Court judges get an extra $6,000 stipend a year, their pay, if they have an accountability court in their jurisdiction. And do you know why the governor did that? It didn't affect Dekalb, because I'll tell you, we've had a drug court, DUI court, mental health court, we've got a veterans court, every kind of court. Tomorrow there could be some new thing where we start a court. But we're in the metro jurisdiction, and this is what dominates our thought, our feelings, and our discussions. But you get outside of metro areas in Atlanta and get into Georgia, and there were not always incentives or monies to start these types of initiatives. So when I say that Governor Deal really rolled it out, when they said, oh, by the way, if you have an accountability court in your jurisdiction, you will get $6,000 more money in your pay. How many judges do you think at that point goes, oh, maybe we ought to start a drug court? Now, granted, I hate that people had to be incentivized, but I do applaud the governor for understanding the need for the courts and the need to incentivize judges to do it, because we can't have accountability courts without judges. Diversion courts, or I shouldn't call them courts because they're not, diversion programs specifically and statutorily are under the prosecutor. So I can start any diversion program I want tomorrow, and I don't need a judge to sign off on it. Accountability courts, though, have to be through a judicially mandated program. So we as prosecutors and as public defenders and agencies could not start an accountability court unless the judges signed off. So I applauded Governor Deal when he incentivized for those judges to just jump on board. He was giving everybody the money. The AOC was saying, you want to start a court, here's the money to do it. but they all knew that without a judge, nobody could do it. So there's definitely those types of courts, when they're run well, because there have been some stories. You know, we've got at least one judge that was removed from the bench for running a drug court that was, I don't even know how to describe the word, criminal. Is she in prison? Oh, okay. Having said that, you know, we want judges to do it the right way, but when done the right way, accountability courts are the alternative to incarceration, because at the end of the day, as a prosecutor, I don't believe that it helps any of us to incarcerate people with substance abuse issues, mental health issues, or problems that we just need to solve with social justice.
I realize there are a bunch of people on the queue. We have time for one more question. This is Jennifer Tillman from SUNY at Albany.
Thank you, everyone. I really enjoyed your talks. And so my question is primarily directed at you two, but I think we'll expand. So I was interested in your center because it's a human rights center. And so I was really interested to know how you guys use human rights to fight for people in Georgia. So do you guys appeal to the Universal Declaration of Human Rights, or do you appeal to existing human rights statutes? And if you do, how does that translate into policy? Because human rights are a great thing, but generally in the United States, people are not always interested or want to hear about human rights. So asking you this question, I then ask if they gave a human rights approach to, you know, helping people who are, you know, repeat offenders or something like this, would you be open to hearing it and then implementing it?
So we are called the Center, I'm sorry, I guess, and you can hear me anyway. We are called the Southern Center for Human Rights, and that's because we feel that the rights of people within our criminal legal system, you know, they do implicate people's basic human rights. You know, whether you're incarcerated and you're given enough food, or, you know, you go through our court system and you're given, you know, adequate, you know, right to counsel and such, you know, those are basic human rights. Unfortunately, we are not always able to couch our arguments in that kind of, you know, Universal Declaration of Human Rights and such. I mean, it's hard enough to get some courts to even recognize people's constitutional rights, let alone, you know, the Universal, you know, Declaration of Human Rights. And so, you know, the fact that we can't even get some people on board with Georgia law or our federal law just means that going that extra step and talking about what's happening in Sweden is just not really going to get us that far. But we never shy away from the fact that the work that we're doing, you know, is a human rights issue. It is. It's just a matter of how you frame it. And we never shy away from the fact that, you know, our clients' constitutional rights, whether they're poor or brown or black, are no different than a person who is of means or white or et cetera. Yeah, I don't really have too much more to say about that, but I think I got at the gist of your question.
Yeah, and I guess I would say I approach the policy work in a very practical way, and that's why I was even in some of the sessions earlier trying to figure out how do I translate this into an effective public policy strategy. And I commend Governor Deal wholeheartedly. I think we would not be where we are in Georgia with the reforms that we have if we had not had the leadership that we had in him. But he did not enter this space around any kind of human rights. We are just treating people so badly in the system. Oh my gosh, it's horrible. Now he will talk about it. I mean, he will say, and it will be a part of a very comprehensive way that he talks about reforms. But why we started criminal justice reform in Georgia, why most conservative Republican states in this country have executed reforms around how we deal with nonviolent offenses and trying to figure out how to, is about fiscal imperatives and fiscal crisis. So when Governor Deal comes into office, it's 2010, 2011, right? We are on the heels of a very bad recession. We were spending $1.2 billion a year on our correction system, and we were yielding a 30% plus recidivism rate, right? So 1 in 3 people are coming back in 3 years. We're just wasting tax dollars. When people can stay in their community, so when she mentions accountability courts, right? It costs $52 a day to incarcerate someone in a prison. It costs $4 a day to manage them on probation. So in terms of like how we think about alternatives, and that's why when you get to a human rights conversation, there are a lot of problems with probation. There are a lot of problems with accountability courts that get to a continued oppression around having a label of being a criminal, having a conviction, right? Still going through the system, what it means for access to opportunity. So I feel like we're moving the parts around, and I think our role in this is to try to get as much impact as we can. And if we could appeal to your senses around how bad this is for people and lives and families, if we could show pictures of kids holding the sign that says, I'd like to see my mom, or I'd like to visit my mom before she dies, or whatever, any of that kind of stuff, if we thought that would carry any water, we would use it. But instead we say things like, how about we think about ways to turn people from tax burdens to taxpayers? How about we think about a way to make our system run more efficiently so we won't be wasting our dollars as people cycle through? And so unfortunately, while it would be nice to talk about it in the way that our hearts and minds are centered around it, that's not the way that we effectuate policy change, at least not in the South.
I just want to give one example. I actually have used the human rights framework once before, and it was around juvenile life without parole in California when we were working on a bill there. But that's a very specific example. And I just want to say that given how unprecedented our incarceration rate is globally, I think it's hard to make those arguments because we have a criminal justice system that looks so different than other countries. And when it comes to those treaties, there isn't really teeth. So it's hard, it's really just appealing to, no other country is doing this, but we're doing a lot of things that no other country is doing when it comes to mass incarceration.
Thank you all for coming, ladies and gentlemen. Please join me in thanking our panel, Sherry Boston, Doug Ammar, Benadette Rabuy, Ateeyah, Hollie, and Marissa Dodson. Our panelists might stick around for a minute or two if you want to chat with them. There's still some food left over, so help yourself and hope you all have a great evening.